Next case is Dexter Austin Apartments
So what that means that
is versus Bithia
You
Nara
got
Velasquez
$10,000,
and
bitch.
Arturo Rodriguez. Who's here on behalf of Dexter?
I'm here, Your Honor. Yes, me, the Dexter.
Yes, okay. And is Bithia Velasquez or Arturo Rodriguez here?
They did not check in during check-in time, but Ms. Velasquez did say that they were planning on being here,
Well,
or they're trying to log on.
they're trying to log on?
Yes, but that was almost an hour ago. If Ms.
Okay.
Rodriguez, so if that's you on the phone, you'll push *6 to unmute.
Before we even get into today's footage, let me prepare you for what you're about to see, because this is not your average courtroom chaos. What starts as a routine eviction hearing in Texas quickly spirals into one of the most unhinged Zoom court moments you'll ever witness. We're talking shouting, swearing, alcohol-fueled confusion, and a defendant who seems completely unaware that she is, in fact, speaking directly to a judge. Then, just when you think the madness can't escalate any further, we jump to Michigan, where the tone shifts from ridiculous to downright dangerous. A defendant accused of violent crimes attempts to play the victim, while evidence paints a picture of intimidation, threats, and complete disregard for court orders. These cases show two very different types of courtroom disasters. One fueled by chaos and entitlement, the other by calculated menace. Stick around, because both of these judges are about to remind everyone exactly why court is not the place to test patience or reality.
We've got Dexter Austin versus John Adame and Melissa Baker. Is that you, Miss Yasmin?
Yes, ma'am.
Okay, you were previously sworn. The rent is $10.13, is that right?
Correct.
And you just want July prorated at $9.80, is that correct?
Yes and no. Their lease contract expired on the 24th of this month of July.
Okay.
They're still current. Hold on. I'm sorry, somebody's here screaming. Oh, I think Bithia's here. Hold on. She's Bithia. Oh, no. We're not doing that. We're on court right now. Give me 1 second.
no, you are she already dismissed my case.
She did not dismiss your case. The reason.
Okay, sí, que yo estuve esperando una pinche hora.
Okay.
Una pinche hora.
Give me a second.
Don't be fucking like that.
I was not. You were not on the phone.
I was on the fucking phone. Do you need fucking?
Okay. You have to give.
Aquí.
Okay. Do you want to go and log in? Because you're literally online.
I can't fucking log in.
Okay.
I couldn't log in.
Bithia, you have to call. You have
Yo
to.
llamé una mira, aquí te voy a enseñar las llamadas.
Tell her to go try the phone number again, Miss.
Una pinche hora.
Do you hear the judge? Bithia, do you hear the judge? She's telling for you to log in.
Velasquez.
I can't.
Miss Velasquez.
Tell me and I will.
This is where things quietly cross the line from mildly awkward to full-blown courtroom disaster. On paper, this is a standard eviction case. Missed rent, expired lease, unpaid balances. Happens every day. But the problem here isn't the paperwork, it's the complete lack of composure from the defendant. Zoom court requires one thing above all else: basic cooperation. Muting, unmuting, listening, and respecting the process. Instead, what you're about to see is a defendant who's already emotionally charged, clearly frustrated, and very possibly under the influence. The judge has been patient. The plaintiff is actually trying to help her reconnect. And that's what makes what's coming next so shocking, because instead of gratitude we get aggression. This moment matters because judges remember behavior. When you turn a simple technical issue into a verbal meltdown, you're not just hurting your case, you're torching it in real time.
Try the phone number again.
Mira, una pinche hora. Wait, mira.
Look, listen.
Mira, 54 minutes. Right here.
Miss Velasquez.
54 minutes. I was waiting.
I understand. We tried to message you.
I can't log in. They didn't give me the passcode. They gave me the fucking.
There's no passcode. You just need the. Can you try again, and we'll let you in right away.
Don't dismiss. The what?
You're on live, by the way.
I know I'm not lying.
Ms.
And I've been
Velasquez,
54 minutes
She
on this
told,
fucking case. 54 minutes.
I
Almost an
know.
hour.
Can you
Really?
try? Can you call again and we'll let you right in, okay?
They didn't give me the password. They gave me the passcode.
there's no
They didn't
password.
know.
Look,
Vergas, ¿cómo que no?
look, just dial right here. Look, dial this number.
Tell her to dial the number and we'll let her in.
There's no reason.
There's no
Mamacita,
reason.
mira, mira, mi amor.
I
Mira,
understand.
55 minutes. That was rica.
That's how
55 minutes. Like, really, look. Progress. Que no me encabrone. Que no me encabrone. Oh,
I'm sorry.
Yo me calmé.
Hold on,
We have 3 more cases, right, Miss Yasmin?
I'm sorry, I can't hear you, Your Honor. It's just that I have her in the office and I cannot hear you. I'm sorry. We were
Okay.
going based on John Adame's case,
No,
and
go back to
then,
Velasquez.
hold
Right.
on. John Adame, actually, their lease contract expired on the 24th of this month.
So
They
that
have not,
would be $784?
correct,
Okay.
which is their prorated amount, plus this amount for the remaining of the month. They have not yet also paid the rents previous, also, sorry, Your Honor. They have not paid a little bit of their June rent as well, so I'm trying to grant possession of
No.
the
Que go back to my case, and I'll speak to the judge. Porque a mí ni siquiera me dieron el pinche paso.
Yes, I want to get possession of this unit of John Adame and
Mira,
Melissa.
Marisa, mira.
Okay, is there any left owing in June?
For the month of June, it's $213, Your Honor.
Okay. So it's 997 is what,
Correct.
okay.
Yes,
And the appeal bond is 2026.
correct.
Okay. So we've got Dexter versus Jonathan Rodriguez.
Yes, for Jonathan Rodriguez, he has not paid for the month of July, which is this month.
Right.
Lease
I just heard her and her.
lease contract expired, July the 3rd of this month, of this year.
Okay.
Their rent is $1,335, so I'm asking for $1,335 along with late fees and, judge,
I can just give you, the background.
correct, yes. Okay, so I need you to just have a seat and we're gonna go ahead and call.
Okay, well, cuando yo estaba hablando, when I was talking, I was like, hello, can you hear me? Almost an hour. Aquí está, in the record. Almost an hour.
Yeah, you wanna take a seat?
You have a seat and then she can go ahead and give you a call? You can go ahead and.
No.
I think she was the phone number, and I called out to push *6 to unmute.
Did you hear she said? I'm sorry, say that again?
If you're calling in through the phone number, you push *6 to unmute, and I repeated that a few times before we started the case.
You heard that, Vidya?
I heard that. I didn't hear that before. My fault.
And here it is, the exact moment the courtroom goes completely off the rails. This is no longer about logging in or unmuting. This is about control, or rather, the complete loss of it. Notice how the defendant isn't just frustrated, she's confrontational, dismissive, and openly hostile while court is in session. She's interrupting, swearing, yelling, and arguing with someone physically in the room while a judge listens. That alone is catastrophic for any legal outcome. Judges don't need to raise their voices here because the record speaks for itself. This exchange shows a pattern: refusal to listen, refusal to follow instructions, and zero respect for the authority of the court. And here's the kicker: none of this helps her eviction case. Rent doesn't get paid louder. Deadlines don't move because someone is angry. Every second of this outburst is digging the hole deeper.
This is the People versus Christopher Moore. I have misdemeanor files 241722, 241589, 241136, and then we have a felony file. This is 241796, FY appearances.
Morning, Your Honor. Jeffrey Fanto on behalf of Mr. Moore. As to the state cases, we've waived formal reading, asked for warrants to be recalled. As of the city case, that's set for pre-trial 5th, and request, would waive formal reading and stand mute.
Okay, so as to, 241796FY, the felony case, this is a charge of home invasion, third, and domestic violence. Mr. Moore, you have the right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have the right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you. You have 2 court dates within the next 21 days. Your first court date is your probable cause conference, which you can appear at via Zoom, and that is set for August 26th of 2024. Following that, on September 9th of 2024, you will have your preliminary examination. At that examination, the prosecutor will have to show that a crime was committed and probable cause exists to charge you with that crime. With respect to the remaining 3 cases, we have a State of Michigan versus Christopher Moore on 1136. State of Michigan versus Christopher Moore on 241589, and then we have a City of Taylor case 241722, and that's the B&E. As to all of those, the warrants have been set aside. They'll be set for pre-trials.
Judge, I would note that Moynihan is on. I would just ask that the 2 misdemeanor state cases be set for the 26th as well.
The misdemeanor state case be set for is the 26th, so that's a Monday?
That's the same day you set for the PCC.
Oh, okay, so we'll just have them
all the same parties.
All right.
Then the state, or the city case, I think is September 5th, if I'm not mistaken.
Yeah, there's a date of September 5th on that one. And then Ms. Moynihan, all 3 of the felony matters, then when we come in for the arraignment, or I'm sorry, the probable cause conference on August 26th, we'll just have those 2 misdemeanor files follow the felony. Now, as to bond. Ms. Moynihan, is there anything you have to say as to bond?
Yes, Your Honor. Thank you. Tina Moynihan on behalf of the people, P8 Force 22. Judge, we were in court on Monday. I was there as the prosecutor covering the docket for Ms. Sob and Ms. Davidova, and Mr. Moore was supposed to appear for an arraignment. He did appear by Zoom momentarily and then disappeared. He would not speak with Mr. Gizicki. With my understanding, Mr. Gizicki attempted to have conversations to proceed with the arraignment, and then Mr. Moore decided to log off before the case was ever called. My understanding, he then contacted the courthouse and spoke to a clerk downstairs and made threats to the court that if he came up to the courthouse that something was going to happen to people in the courthouse.
This is the point where reality finally starts tapping the defendant on the shoulder, and she still refuses to answer. The court has waited. Instructions have been repeated. The judge has shown more patience than most people would after being sworn at on a live record. But courts don't run on chaos, they run on procedure. When a defendant fails to properly appear, fails to comply, and fails to control themselves, the court doesn't pause indefinitely. It moves forward. What's important here is that none of this is personal. It's procedural. Missed rent, expired lease, no proper appearance. Those facts don't disappear because someone is upset. And when the dust settles, the outcome becomes inevitable. This case wasn't lost because of technology. It was lost because of behavior.
And then it was also my understanding of speaking with the complainant who appeared by Zoom that there was an incident in the night prior, which would have been Sunday night. In that incident, Judge, there has been a warrant requested. I am in the process of reviewing that this morning. The allegations there are that the defendant broke into the complainant's home again overnight, forced his way into the home. He then adjusted cameras throughout the home that the complainant had so that he could not be observed. He's seen wearing all black, a hoodie, as well as a mask covering a portion of his face. He then enters the complainant's bedroom. He pulls a gun from his pocket and then shows that to the complainant, claiming that her fingerprints are on that gun and putting her in fear of an altercation ensuing further from that. He's then seen leaving the location by the complainant and heading out in an unknown direction. My understanding is that he's been staying across the street at the home across the street from her residence, and I believe that that is also going to be considered a violation of his bond that's been issued, that he's had no contact with the complainant, that he's not returned to that residence, and then there's allegations of new criminal activity. In addition, Judge, to his failure to stay in court until the case was called on Monday, I do believe that Mr. Moore is a danger to the complainant as well as to the public as a whole. He shows a wholesome inability to comply with the court's orders. I would be asking for a $250,000 cash surety bond, no 10%, with a GPS tether and house arrest if he were to be released. And I would ask that there be a 2-mile radius from the complainant's residence so that he's not to return to that area.
The tonal shift here is dramatic, and it needs to be. We're leaving behind chaotic comedy and stepping into something far more serious. This second case isn't funny, awkward, or absurd. It's alarming. From the very first moments, the charges alone signal danger. Home invasion, domestic violence, multiple pending cases. This isn't a misunderstanding or a paperwork issue. This is about a defendant who repeatedly ignores court authority and escalates his behavior when confronted with consequences. Judges see patterns, not excuses. And as you're about to hear, this pattern includes threats, intimidation, and a complete disregard for public safety. This is where the courtroom stops being a stage for drama and becomes a safeguard for victims.
Anything, Mr. Fanto?
Well, I guess we have allegations that I don't know that the court should take into consideration relative bond as these cases stand. However, I would note that Mr. Moore does have some serious medical issues. At least if we could mark the files on medical so that Wayne County knows. He is on SSI.
Okay. I don't think there's, the things I'm to take into consideration is whether or not he's a danger to the community. He's a lengthy criminal history. His behavior in this court has been absolutely egregious. Since these cases have started, he has assaultive criminal convictions. He clearly does not have any issue ignoring court orders. He is certainly a danger to Miss Butcher as well as the community at large. He's certainly a flight risk. He was already in immediate warrant status on one of the domestic violence charges on August 5th when he failed to appear for court. We've had a separate case where he had an immediate bench warrant on 2 different dates, both June 13 and August 5th, for failing to appear at court. He's now got pending against 1 complaining witness, 2 domestic violence cases, 3 domestic violence cases, a B&E and a home invasion. There's an allegation that a firearm was used in one of those instances. There was a police report filed. Detectives had to come over to the court Monday after there were allegations that Mr. Moore called the court, was extremely volatile with court staff. And Ms. Moynihan, the language was that he was going to come up to the court and commit a massacre. That's the allegation of what he was screaming at court staff.
Let's be absolutely clear about how serious this moment is. Threatening a courthouse is not venting. It's not frustration. It's a crime. Courts take these statements seriously because they have to. Judges, clerks, attorneys, these are real people in real buildings. When a defendant calls and suggests violence, that immediately changes the entire legal landscape. Bond isn't about comfort anymore. It's about containment. And what makes this worse is the timing. This wasn't years ago. This wasn't hypothetical. This was recent, direct, and connected to an active case. Judges are trained to assess risk, and every detail here points in the same direction: escalation. Once threats enter the record, Leniency exits the room.
So I have to agree with you entirely. Mr. Moore is a danger to the community. Mr. Moore is a flight risk. Mr. Moore has shown absolutely zero respect for the criminal justice system, the legal system, or the safety of his own child that resides with Ms. Butcher. He will have a $250,000 cash or surety bond with a GPS tether with a 2-mile radius of complaining witness's home. The file will be marked medical. Mr. Moore, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with Ms. Butcher. And a matter of fact, you can't not only go to her home, you can't go on her street. These are on the felony case. These are the bond conditions set for 1796 FY. You are not to possess or have access to firearms. You cannot purchase or access or consume alcohol or illegal drugs. On misdemeanor, I've also signed the request for a court-appointed attorney to ensure that Mr. Moore has counsel at all future proceedings, and that's in the file. As to the 3 misdemeanor files, each of these files will have a $10,000 cash surety bond with a GPS.
Top of 250,000.
No, that's plus, so it's 280,000 altogether.
Hey, ma'am. If I can say something when you are done, please just let me know.
Mr. Moore.
Mr. Moore, you have a.
Prefer you not.
Yeah, Mr. Moore, you have a constitutional right to remain silent. Given the amount of hot water you're in right now, I would strongly encourage you to follow the advice of your counsel.
We've got pretrial services relative to the felony.
I will request a DSU report at counsel's request on the felony. Is there anything else?
Yes. Can I say one thing, please?
Mr. Moore, your attorney's advising you not to say a thing.
I understand that. I'm asking, please. Would that be okay?
I would prefer you not, Mr. Moore.
I understand that, I respect that, but this is my life in the balance and me ever seeing my kid. So I would like to say something.
This is the moment where the courtroom goes silent, because these allegations are terrifying. Forced entry. Cameras deliberately adjusted. A masked intruder. A firearm produced in a bedroom. This isn't impulsive behavior, it's calculated. It shows planning, intent, and a complete disregard for the victim's safety. And when you combine that with bond violations and court threats, the picture becomes unmistakable. Judges aren't weighing sympathy here, they're weighing risk. Every detail reinforces the same conclusion. This defendant cannot be trusted to follow orders or respect boundaries. The law exists to intervene before tragedy happens, not after. This is exactly the type of case where preventative detention becomes necessary.